On PM Express tonight, tackling the breach, EC's controversial sale of public data. It's about the EC, yes, because that is what the Auditor General found. But as we discuss this, you'll find out there are many state institutions that you deal with on a daily basis who hold your data. And the question is, what are they doing with that data? How did this come about? The Auditor General carried out what we now know as a special audit on some key institutions dating back to 2018. What did we find as a result of this? We found, based on what we now know, that one of the key institutions that was looked at was the Electoral Commission. The Auditor General discovered that EC has sold data of voters to a private company called Buy Systems. Now, Buy Systems Limited was to pay 20% of the fee collected on the quarterly basis to the Electoral Commission. In other words, they were selling your data, your electoral data, the data that you give the EC, your name, where you live, where you work, etc., that the EC collects, for which reason you get a voter ID card to vote. The Electoral Commission was selling that to this company. And this company was taking that and was supposed to pay whatever amount they get, a percentage of that, 20% to the Electoral Commission. But what did the Auditor General find? Auditor General found that between 2016 and 2017, the financial year, the company failed to remit the 20% commission due to the Electoral Commission. So yes, the Electoral Commission sold off your data to a private company to make profit, so that the private company then pays the Electoral Commission part of the money. The private company makes the money and doesn't even pay, although your data has already been sold to them, right? There was also no agreement, and this, I guess, is the part that alarmed a lot of people. There was no agreement covering the sale of your electoral data. The EC just handed it over to the private company, and they signed no agreement. The Auditor General found no agreement to this. However, we did our own checks, and we found that the Commission suspended whatever agreement that existed, the third quarter of 2016. That's what we found. But the revelation has also raised, as you know, concerns about breach of privacy, trust of many Ghanaians who gave their data to the Electoral Commission to also process and use for election purposes. The reason by law that we gave the data to the EC so that they gave us a voter's ID card that we vote. Nobody consented to the Electoral Commission handing over your data, selling it off to a private company, which then sold it to financial institutions. Have you wondered how the financial institutions managed to call you in the middle of the day and say they are selling you a product? It's because somebody has sold your data without you knowing to them. That is what we are interrogating today. There are many fundamental questions to ask. Has there been a breach is one of the first things we need to establish. And then, is your personal data really safe with the state institutions? And you'll find that not only with state institutions, with your regular everyday private organization that you deal with, your data. Elsewhere in Europe, this is a big issue. Companies like Google, like Facebook, have been fined millions and millions of dollars and euros because they violated people's privacy. What is going to happen to the likes of the Electoral Commission? This is where we uncover all that tonight. Stay with us. You're live on PM Express tonight. There's a conversation that we have rarely had in this country, but one that affects your life and mine as well. Elsewhere in the world, as I indicated in my intro, in Europe and the US, it's a big conversation. Volumes of research and books have been writing about what is arguably the world's biggest next thing in terms of wealth and volume and value. Data. Your data. You wonder what Facebook does with that? Oh, well, in this country, we're talking about the Electoral Commission. It's come up, and we thought maybe this is the time to use it as a basis to confront a subject that we haven't had really in this country. And that's why I've invited people who understand this. And with me in the studio is Miss Patricia Dusay-Poku. She is the Executive Director of the Data Protection Commission. Thank you, Madam, for your time here on PM Express. Also joining me is Dr. Kojo Asante, is the Director of Advocacy and Policy Engagement at the CDD. He's also a legal practitioner, a lawyer. Thank you, Kojo, for joining me. So I will start with what has really triggered this conversation. It was just last week that the Auditor General's report went public. His report into several state institutions that made a discovery. When it first came up, the focus wasn't so much on the data protection angle. It was more about, you know, whether the EC had an agreement and the fact that monies were not paid to them, although there was some form of agreement to that effect. And what did the Auditor General find? The Auditor General found that fundamentally, that the Electoral Commission had some form of agreement that didn't really exist, that the Auditor General says that it couldn't find, with a company called B Systems. The B Systems or Buy Systems took the data and they were supposed to sell off the data to financial institutions. They make money out of it and they pay 20% of that as commission to the Electoral Commission. Now, the interesting thing about it is, the Auditor General found that although that was the arrangement, they didn't pay the money to the EC, but also they couldn't also find any agreement to cover this. So we've dealt with the corruption angle, which has been raised. Where is the money? Did they make money? How much did they make? How much did they pay to the EC? We'll talk about that briefly, but substantively, there was no agreement to cover this. And meanwhile, your data had gone already to the private institution. Madam, tell me about this. So, has there been a breach?
So, to establish whether there's a non-compliance or not, so we need to find out more about how this relationship with the Electoral Commission is. So, first of all, we have established that the data protection, the Electoral Commission is an established data controller with legitimate grounds to collect data. They, on collecting the data, should have been clear about the purposes of the electoral database, who can have access to it, when they can have access to it, why they have access. So that's the justifications documented, the purpose of sharing. Obviously, there are some groups who may need access to it, but on what basis, on what legitimate grounds, for what purposes, for how long, what's the retention policy. These are bits of information that should be documented and made available in advance, if possible, to the data subjects, which is you and I.
Okay.
So
here in this case, the electorate.
Yes.
All of us who show up to register to vote.
We are the data subjects. So the electorate of Ghana should have been given that transparency in order to be able to either object or request that they are made ex-directory, so that people can opt out for from being shared to other third parties. And if they had to be shared, there has to be clearly documented reasons and justifications for it. We have a list of bodies who have an exemption under the law. But private sector institutions have to have grounds for accessing the data and for clear purposes. The absolute no-no is for marketing purposes and for profit making.
Okay.
So what we need to be clear about is the purpose for which it was shared, what volume was shared, why was it shared, and for what, under what justification. Okay, if it's for marketing.
When you say the absolute no-no, according to what, the law?
So yes, according to the data protection law, you cannot.
2012 Act.
Yes, you cannot collect personal data and without the consent of the data subject, use it for marketing or for profit making and unnecessarily.
Okay.
So if you're going to do that with the data, then you must let the electorate know at the point of collection, which obviously hasn't happened. So
in other words, they need our consent to do that.
Yes, but in some circumstances, they don't need to collect your consent per se before creating a database such as the electoral register.
The intention to
the purpose should have been clear in order for the data subject to react.
So what you're saying is, when I show up in the booth to register, there must be a form that spells out that I'm collecting this data, and one of the reasons, one of the uses I'm going to...
what, when, why of the data.
Your data could be sold.
Yes.
And I must agree then to say, okay, in spite of I haven't read it, I still
Because there's one clear purpose for the electoral register, that is to enable us to vote.
Which is why we all vote register.
Anything beyond that should require the consent of the data subject.
Interesting. In this particular instance, the Auditor General has found that indeed the data was given to a private company, which then gave it to financial institutions, and they were supposed to make profit and pay back the Electoral Commission. You read the report, I'm sure.
Yes.
What does that mean in terms of the legal framework?
So today we have written to the Electoral Commission. We've requested for a copy of the contract to see how the Electoral Commissioner has conferred its obligation on this third-party contractor. In order to share, you need to put together information sharing agreement in the list, if it's not a contractual agreement, that the person accessing the requester needs to make a formal request, and then the giver, the data controller, needs to outline how the third party should meet their legal obligation, which is the obligation of the Electoral Commission to continuously safeguard the data. So they need to confer that responsibility they have on this third party organization by outlining in simple step-by-step instruction to that third party how they continuously safeguard the data, presuming that it's still for the purpose of votes. If it's outside the scope of the original collection purpose, then clear justifications must be documented.
Outside the scope, as the Auditor General seemed to suggest it is.
Exactly. Okay. So the contract between the Electoral Commissioner and the third-party organization should clearly outline why the sharing is happening and what justifications, what legitimate grounds allows them to share. Because there may be a law that allows the Electoral Commission to share data in these circumstances. So we've requested for...
To share data with the private company, to on-sell to...
There are so many laws in Ghana, so we don't assume that we know them all.
Okay.
So we have made a formal request to the Electoral Commission.
To do what exactly? To furnish you the details?
To furnish us all
the contractual details?
All the documentary evidence, including the contract.
Covering the exchange of this data with this private organization?
Yes. We've asked for a list of documents, including the contract.
Do they have, how long do they have to comply?
We get them 21 days from today.
Okay, to provide the data?
Yes.
Okay.
Because we've asked for quite a list of documents, the justification, the legitimate grounds. So basically, under Section 28 of the Act, the Data Protection Act, you'll find that they have to have appropriate technology and organizational measures. So on these two areas, we've asked for all the evidence of appropriateness and that the technology chosen, who's the supplier of the technology. You know, there are two issues why we're having to contact the Electoral Register, not just because of the Auditor General's report, but because the Electoral Commissioner herself recently on air declared that she didn't have full access to the database.
True.
So based on that, we've had to ask about the technology in use, who is the supplier, what vendor due diligence was done, what was the contractual basis, the legitimate grounds, how did she confer the obligation on them. When I say she, I'm talking about
the Commission.
The Commission. So this current or previous, whoever made the ultimate decision at that time, what process was followed, what due diligence was conducted, more importantly, what risk assessment was done concerning the data that the third-party organization is accessing, and what decisions were made about the risks outlined, if any.
Very interesting. Kojo, you are an electorate. I presume you are registered to vote. Yeah. I must say I have never registered before, so my data, forgive me, I'll try and register the next time. Yes, I know, I have never done that before. So my data wasn't part of this, so I'm not affected. You definitely have been affected by this, based on what I'm doing. So what's the big deal? I mean, I read that and I'm like, what's the big deal here? I mean, so if you gave your data to some private guy who gave it to banks or whatever it is, and they're supposed to make profit, so what?
I think it's a big deal, and it's basically a question of privacy and you being able to have control over information that's gathered about you. And actually, it's worse if you are exploited. The information you provide to agencies who are collecting that information by law, if they then go to exploit it, for profit-making purposes, right? If data is like your personal data is like your property, if anybody is going to exploit it, you want to be the first person to exploit it.
And we give a lot to the EC. There's a lot you give to the EC. Your bio data. You give your fingerprints to them. That's so sensitive.
But the issue is also about rights. The whole reason why the Electoral Commission is entrusted with this power to collect information is to allow it to carry out a certain mandate for us to be able to exercise our rights as citizens to vote. Anything outside of that cannot be justified. So, but you know, the commission has a job to do. They have to look at the facts, so they can come to a conclusion. But just based on the mandate that is given to the Electoral Commission, I am a researcher. Often we have requested for voter register, for instance, to be able to do an audit of the voter register, and we want it in a form that is soft, so we can do analysis and so on. Often the Electoral Commission will tell you that for privacy reasons, they cannot give it to you. And even if you will get it, it will probably be in a PDF format or a format that is secure, that doesn't allow you to sort of manipulate any data. The political parties get the same kind of voter register if they want to do an audit.
They've always complained about it.
They also complain about it because they also want to do analysis to make sure that there's integrity in the voter register. So when you hear that the Electoral Commission is that comfortable to pass on information, not even for the purposes of elections, but to a private company in a format that the private company can use for whatever reasons, it's quite
The Auditor General says that the private company was then selling it to financial institutions.
Sure. I mean, it could be for credit referencing purposes. We know that the electoral card is one of the identity, forms of identity that banking institution, for example, rely on. So it's possible that was, but all of those facts has to be settled. But if you look at the Data Protection Act, both in Section 88 and 89, there's a prohibition against sale of personal data. Not only for the person who's selling it, but the person who is buying it. So it is not, you know, this is not even the Electoral Commission alone, but those intermediaries who also purchase this data will have questions to answer. So, I mean, it's a serious matter, and it raises certain questions about the Electoral Commission's own systems, and I think that's why I'm glad that the question is also extended to the technology, because who gets to download this kind of information and pass it on to other people? What kinds of conditions exist for them when they are passing on this kind of information? We already know that we had a similar issue while some of the electoral commissioners were removed, where because people could actually go and add manipulate the data. So it raises questions about what kinds of systems and how protective those systems are to protect the personal data of prospective voters.
But what can you do under these circumstances?
So we've
apart from writing to them.
So basically, we've triggered an investigation, and what we are enabling them to do right now is a self-assessment that will give us the information that we need. So instead of us going and launching an audit on the electoral commissioner, we've given them the critical questions that they should be able to answer within the 3 weeks that we've given them. That enables them to look at their systems and their organizational measures and come up with answers for us that we can use to conclude whether we need a full-blown audit or that the information they give us is enough to reassure us that everything is in order. Now, when we get these documents or not, we will make a decision at that point what further action is necessary. Because our critical, what concerns the electorate concerns the commission. Because our main mandate under Section 2A is to ensure the continuous protection of individuals' personal data as a fundamental human right. Any database belonging to individuals in Ghana, in this jurisdiction, that is enabling the manipulation of the data without due control, that results in the questioning of the integrity of the data, the accuracy of the data, or the continuous availability of the data is a concern and a potential breach of the law. So a database such as the electoral registration database needs to be continuously available and accessible, have integrity, be accurate, and give that the electorate that confidence in that commission that 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 the information or their data is continuously secure so that it's as it was given, not changed. Right now, with the situation we have, there is doubt about the integrity of the database, and that in itself is a problem. And so whatever concerns the majority of the individuals in Ghana is the concern of the Commission, because we need to stand in and then speak with the voice of the people to ensure that the data commissioner is acting accountably. And an accountable data controller is one that ensures that there's enough transparency in how they use the data, that there's adequate technology, that the choice technology is appropriate to the sensitivity and the volumes involved that they are holding.
Under the law, what does the law allow you to do to sanction institutions who breach?
Yes. So we have various actions that we can take. In this particular instance, depending on what we get back, we might decide to let the Electoral Commission sign an undertaking with some specific deadlines in which they need to take certain actions. It depends on the seriousness of what comes back. Or we might trigger prosecution through courts.
Yeah, because...
So it could be a serious action or a medium type action, or it could be a cooperation. And if they cooperate with us with the information we have requested, then we will work with them to put things back in order. Because data protection is new to the jurisdiction.
It is.
Many people are learning about what it really means, the implications on the business and the impact on the business itself. So we are trying to engage with public institutions, the high volume channels of personal data, to do the right thing and to be acting accountably and be proactively acting accountably, not waiting for things to happen before they react to it.
No, but you say it's new, but this law was passed in 2012.
It's still new. It's still new.
It's 2012 to date. It's a long time.
Compared to what is on the global landscape.
That's true.
Other countries, other jurisdictions have been doing this 25 years, 30 years, 40 years even. So compared to that, it is fairly new in our region.
That's what makes say you should seize this opportunity. This is a real test case.
Oh, yes, yes. This is a test case, and we are responding adequately to it.
Okay.
We don't want to be hanging so much on the punitive end. It is more important for us and the rest of the nation to learn from this case.
Experience, okay.
Yes, so we have taken the first step. We've consulted experts. We have written to the Electoral Commission. We're waiting for them. We've given them sufficient time for them to look for the document, knowing that even the structure of records in our country is questionable.
Yeah.
So we are asking them, we're giving them enough time to look for the relevant, because we know the Auditor General has gone there, done his audit, and his records
are you bringing in the Auditor General to help assess you as well? Because I read your...
I've already communicated with the Auditor General. They have gone in, they've done their audit, they come up with the audit report. They don't want to be the same people going to investigate.
Because I read your law, and your law says, in fact, in your work, you have to reference the Auditor General's report.
So we have. You
have?
Yes.
Have they furnished you with their own detailed documentation?
Yes, so we have a copy of the report that everyone has.
Okay.
And based on the findings that is specific to the Electoral Commissioner, we have written to the Electoral Commissioner to furnish us with more detailed information to enable us decide which way to progress with this. So we've given them enough time to give us the detail on their relationship with this third-party organization also. And the thing about data protection is once there's a suspected non-compliance, we don't rest on the particular issue that triggered the non-compliance. We do a full data protection audit.
Okay.
So that is exactly what we're doing. We're asking and we have gone beyond the electorate data to staff data as well, because
EC staff data.
Yes, when we come into an institution, all angles of personal data held by that institution falls within the scope of our audit. So the staff within the commission are also data subjects. Because the underlying assumption is any responsible data controller will go all the way to protect all buckets of databases that they hold that consist of personal data, including their staff data.
I see.
And so we've asked questions that covers all the different kinds of data that they hold.
Some have suggested on the back of this, advocates, that we should see a hardline measure that serves as a wake-up call, because there was a time a few years back that your predecessor had gone in to start actually arresting organization who had failed to comply with the part of your law that says that you should create they must register with you as data controllers. I'll come up for you to brief me on that, but some say this is one of those cases where it should be treated as those test cases, because laws are living organisms. Until you test them in court, it won't live properly.
Sure, but I do accept that this is new for a lot of people. A lot of people don't know about this act, have not worked it into their processes. I mean, normally when you even go and I think either for banking services or even the telcos, they will ask you that, do you accept for your information to be to be made available to other third parties, for marketing purposes, or to inform you of deals and so on and so forth. And you take, but those kinds of procedures are what should be, common with all data controllers. Yeah. But we are not used to that kind of, or we haven't put in those kinds of.
So what you're suggesting is that the EC should do something like that and say at the point of registry,
so for me,
do you accept that your voter register?
Yeah, but I think that for me that would not be a justification within the mandate of the EC.
Okay.
Right? So for you,
under no circumstance should the EC be selling your data to any private hands?
To private hands. Okay. I mean, I know that under the National Identification Authority law, the EC data was one of the data sources that it was supposed to be created for this, to connect all the data points to allow for search. But that is under a legal regime that is very clear. There are protections and so on and so forth for national security, and the data protection law is very clear that so law enforcement can use it when they are tracking, they are investigating and so on. That's within the law. That makes sense. But to exploit it for profit purposes, that cannot be the mandate of the EC, right? So the EC cannot say this is. The EC cannot say this is IGF.
But that's the point. That's the point I was going to make. The EC must find ingenious ways of making money to sustain itself.
But we're still within its mandate. So the statistical service, for instance, if you want, certain data and so on and so forth, sometimes you have to pay for, these kinds of data. Even that, there are push for some of these data to be made free so that it's accessible for research and so on and so forth. But if you monetize a data that, personal data that is to ensure that people can exercise a certain right, I think you're going beyond the boundaries of what, by principle, what is acceptable. That should not be. We should fund the EC to deliver what jobs. It has other ways of making money, nomination fees, other kinds of fees for applications and so on and so forth. Even that, it has to only be for the administrative cost of producing whatever service that is done. But this cannot fall under those kinds of opportunities where the EC makes money. And anyway, from what the Auditor General is saying, even that money
it was not paid. It begs the question, as the Commission is doing its work, can an individual take this matter up in court?
Oh, yes.
Sue the Electoral Commission?
Well, at least what I read.
So can I explain
Yes.
that?
Please explain.
Whenever the Commission investigates a complaint, the decision we come out with is called a determination under Section 78. So our decision is a determination as to whether this is a non-compliance, or it is a legitimate action, or it's a complete breach of the law. That decision is each individual take it.
But would that how do you say, would that undercut your rights under the human rights protection?
No,
in our Constitution?
I mean, to go to court without reference.
Yes.
So it makes it easier to go to court if you want to go to court,
but the court will take that into account.
Because our determination is following an investigation. So all the evidence has led to that determination. So the court does not need to go do a further investigation. They only have to request a file from the Commission. So we, as the experts in the nation, have looked at the whole circumstances surrounding the alleged non-compliance, and we have concluded the matter with a determination. The determination is every impacted or affected data subject ticket.
Okay, to seek
either
redress.
seek
Compensation. In fact, I see the law that the person
or
can
claim
seek.
of go to court.
No, but
or
isn't
take
that
action.
a dangerous thing you're suggesting? Can you imagine? Can you imagine all 50 million voters deciding to take the EC on for compensation?
That's why we don't make determinations lightly.
Okay.
That is why the commission is very slow in coming to a determination.
On this.
Because our determination are legally binding. It's by law. It's a part of the law, a decision made by the commission. That's why we like to cooperate with the data controllers. We don't make especially for the risks of class.
Is this the first time you are having to take this action?
On this scale, on this size of a database, yes, but we've made several determinations on very smaller cases. Yes,
because I'm just imagining the many institutions like EC breaching my privacy right now with data that they have. Had it not been the Auditor General that went in to find this, I'm sure
we have issued a lot of enforcement actions this year alone. About 600 of them.
600.
A lot of them.
What's the nature? What is the average? What is the main breach that you discover?
Individual complaining about data controller not respecting their rights or not responding or some dissatisfaction with a complaint about a service they have received or their request for an update to their records. You know, accuracy is a principle in the law. If you spelled my name wrong, correct it, they say no, then they come to us and we make a determination, yes, this person is
and it's your determination enforceable?
Yes.
Institutions respect your determination?
They have to.
They have to is one thing. They actually do?
A lot of them on our first letter to them take action. We don't even get to a determination before they address the
How
issue.
do you enforce your rulings?
So we have the option to either write directly to the institution and actually direct them to take a certain action.
If they don't?
If they don't, we have the right to prosecute them.
As in you go to court. You have your own prosecutors, so you use AG's
we have the AG's fast-track arrangement that they have made for the commission that enables us to push cases through quickly.
And Kojo, you're saying that an individual on the evidence of this can go to court?
Yes, because I mean you have rights under the Constitution. This is a right violation. So this is a right to privacy.
Once it's determined.
Yeah. You see? Well, I mean, no, even if
the Auditor General's report.
So regardless,
is it enough ground?
Regardless, but the point is that if you go to court, so you go to the Human Rights Court, you know, saying you are exercising your right to go and protect that right to privacy, you think there's been a violation that has injured you, so you are claiming for compensation, whatever. The court is going, because there's a data protection commission, would want to know what the data protection has. So, you know, in a way, it kind of, it kind of restricts you in that, but it does not take away your original right under the Constitution to go out and basically claim your right or protect your right under the Constitution. So that is there. But I mean, somebody can sue, depending on what the determination that the commission makes. And it can be costly.
They can even
to the electoral commission.
Yeah, because so one of the things.
Disagree with
exactly. Because one of the things we have to also check is, what did the financial institutions use the data for?
That is a big question.
Because if they, you know, so getting to the conditions under which this agreement, you know, so once the electoral commission provides this information, then it's almost like the second step. All right. So how did this intermediary use this information? How did the final recipient use the information? If it turned out that, for example, then they proceeded to use it for marketing purposes.
It depends on how they access it.
Sure.
So we've asked the question, is it by accessing a database, by viewing?
Yeah.
Is it a download? Is it an extraction of the original database? Is it a replication of the database? Is it sitting on their side or within the EC? Was a retention period agreed? So are they having it forever or for a period? Is it a one-off sharing? So we need to know the detail of the sharing.
But in spite of all the questions you're asking, I think the fundamental point Kojo is making is that even irrespective of all that, what did the ultimate recipients, that's the financial institutions, use that data once they received it for? I mean, if they discover that they use it for marketing purposes.
It all depends on how the EC conferred the obligation on them. What restrictions was given to them? Okay. Whether
you see, so I see three parties here.
Yes.
The EC, this private firm that acquired it, and then the ultimate financial institution that then takes it. I think his point is, the financial institutions that bought it from this intermediary between the EC, what did they use that ultimately for? I think the Auditor General has cleared it for us. What the EC and the buy systems guys use it for. They sold it. But what we don't know what the financial institution use it for.
Yeah, but we also don't know what conditions that they had with buy systems.
Buy systems, true.
So
because
that's why they kept talking about the service level. You know, what is the service level agreement that they had? What are the conditions?
And how accurate?
And did they comply with that or not? You know, so they are. I mean, this is just the first step, but that's what the commission has done. Once they have asked for this information, then it would lead to further questions if they feel that they are not getting the right.
Now, there's another fundamental point that I raised earlier about register, getting onto the data register, the commission's register. Every institution that is a data controller, including this institution.
Read section 91.
Yes.
It binds the Republic.
Yes.
So everyone under the umbrella of this Republic
must register with you.
Must register with the
Many people have not. And I dare say we haven't.
Millions.
Because we keep a lot of data here.
Oh, yes.
But you were supposed to sanction us.
You have a letter from us. Go and look at your record.
You haven't written to us?
Yes.
When?
We have it on record. I can't tell you.
But here's the point, though. The law allows you to sanction severely, I must say, because if the penalty units are quite severe.
50,
Yes. We at some time in the future, 2 years ago, I think it was, police officers were aiding you to arrest heads of institutions.
They still are.
Are they?
Still are. We still have that relationship with them, and they are involved in the issue of these enforcement letters that I spoke to you about, that we've issued 600.
Yeah, I haven't seen them here.
So, well, maybe you're inviting them tomorrow. Yes. But we don't pick our battles. We need to plan and strategize. Sometimes we hit specific sectors. Sometimes we go to a catchment area. And we're working out. It's a small commission and the whole nation.
Yeah.
And so we sometimes operate at the regional level, sometimes within a catchment area in Accra, or we test out a certain industry body in the issue of these sanctions. But it's a learning curve for the commission too, and we are growing into shape in strategizing with the results we are getting with the catchments we are testing, and deciding what are actually the responses we're getting from data controllers as to why they're not responding. And we found that a lot is because of the lack of understanding and awareness of the law. And so my approach is not like my predecessor, not with the strict punitive action, because I do clearly understand that there's a mandate on the commission to raise awareness in the nation. We have had to sometimes step back, build internal capacity, so that
do you have the capacity now?
Well, it's not as we want it to be, but it's so much better than what I inherited in 2017, when there was no practitioner at all in the office or in the nation that I knew about. I was the only certified practitioner that I knew about in the country. When I took office in 2017, there was not one known to me, not even my predecessor.
Yeah.
So how do I then go insist that
everybody
that you have that I'm going to fine you when you don't have a practitioner to help you input a privacy program in place? And so there are real issues, and it's not about Ghana only. There's a global skills deficit
in this area
of certified, because data protection, like I said to you, is new to the world.
This is a multi-billion-dollar industry.
So yes, globally, the last time I checked, the world was short of 79,000 certified practitioners of privacy. The world was short of it. There was none in Ghana, as far as I was concerned. So I had an immediate need to create certified professionals in the country. And to date, in the last year, I've trained 100 certified professionals in Ghana to the international best practice standard, and placed them in various public sector institutions. So they are now doing the gap analysis within these institutions to look at where they are currently against where they ought to be. And the gap between is the list of risks that we are presented with. They are analyzing the situation so we can understand the maturity state of these various institutions and get a list of risks that the key decision makers need to address First one being that the fact that they should register with the commission, so we know they exist and understand what they are collecting data for, the size and volume of their database, the sensitivity of their data, the purposes declared, and what that means practically for their business. Because people need to understand the implications of the law on their business. We need to be able to convert the legal speak into practical business action for key decision makers to take action. And we need to, if you look at Section 58, there's a responsibility on every established entity in the country to train an individual as a data protection supervisor. And I've trained almost 100 of them.
Now you have a bigger challenge, and Kunju, that's where it gets interesting. All of us sit on social media. I mean, the rest of the world is talking about Facebook and Google, and you're finding the millions and sometimes billions of dollars just because the fear of Facebook breaching privacy laws. In Europe, there's a huge fight. I mean, slap them with huge fines already. We sit in Ghana. We're on Facebook as well. We're on Twitter.
Very much, yeah.
We're on WhatsApp. We're giving
global.
We're giving up all this data to them. Where you live. In fact, I'm surprised each time I go into any place. Immediately I leave, Google will send me. Did you enjoy the place?
Yes.
So
because you put your location data.
And I'm like, did you enjoy the place? And that is, I'm always alarmed at that. It knows where I've been.
Exactly.
In fact, somebody told me it tracks
you.
Every month, you can go to a part of Google and it will show you every place you've been.
It's like the Matrix.
Right? And my question is, why are we not, the rest of the world is awake to this because of the implications they know. Elections have been decided elsewhere in Europe, in America, because of who has control over people's data.
This is why location data makes.
And we are in this country. We don't seem to be.
So I mean, they are much bigger, and you see, these things are going to unravel very quickly. So this is not even just about the sanctity of elections, but it's also about the digital economy. And if you think about mobile money and the financial services all going digital, where a lot of information.
The data aggregation becomes very easy. So it's easy to manipulate electorates based on their locations.
And then you have to think of machine learning. That is, so the processing, if you look at this law, the processing parts of it is, that's where a lot of the issues about control and so on comes in. The technology for processing is changing so quickly, and this is transnational. So for the organizations like our commission and so on, it needs international action to be able to enforce rights across states. Because Google is sitting, in various places, it's collecting your data from what does that mean, in terms of your rights. Because Google is exploiting it gives you, consent for.
Only last week Thursday we had a big meeting with the UN and Google and all these artificial.
They have offices here, right?
So we've had a meeting with them about the ethics of processing for artificial.
Is Google in Ghana registered with you?
No.
Is Facebook registered? They have offices here.
No.
Why? So everywhere they operate in the world, they are required to do so.
We are working with them to sort that bit out. So
because
they know they have to.
They may be subject to sort of American data protection laws. So this is an American company that has a subsidiary in Ghana. But the point is that Ghana also has a law that says requires you. So there are all of these things that at a certain level, there has to be a transnational agreement about what the standard is. Which, I mean, from what we are doing, not different from what other people are. Just recently, if you have any data in Europe, there's a request for you to recertify that or provide additional consent that this should happen to your data and so on. So the law enforcement there is stronger, and basically we are trying to get there. But the issue is huge, and I think education is key. And when we get cases like this, it should also be a learning moment, but also a wake-up call for all of us to take an interest in these things. But I think what the commission is doing and how this case unfolds is something that we should watch. What would happen in terms of what is the reforms, what are the mechanisms that the EC will have to put in place to make sure that now the data is protected. We know the conditions under which data would be provided and so on and so forth. That should be our interest. So that we don't come back to this kind of breaches again.
Are we doing, on the back of this, are we doing an audit of all these state institutions who collect huge volumes of data?
Yes.
Because I'm thinking we should.
Yes, a letter's gone out, a notice has gone out to all of them, especially those who have
Which
trained.
institutions are these? Are you looking at?
Oh, I can't from the top of my head tell you, but many institutions.
State institutions.
Yes, have received notice, about 100 of them
100
this
state
weekend. To for those who have trained practitioners, get them to do their risk assessment and send it to the commission by the end of this week. The rest of them are on notice to send people for training and also to take action. Most of them in the last few months have even ministries have registered with the commission. So there's an uptick of registrations and action from especially the state institutions. A lot of them are taking action now. Many of them have done excellently. Institutions like SNIT, NCA, Ghana Post have trained multiple professionals to take action on their behalf. SNIT, for example, has trained all the executive body. They've trained all their executive body in a half-day session with me personally, and then they have trained various practitioners, and now they have identified several middle management to go through the training. Many of them have taken action. Today I had several letters on my desk from private sector and public sector institutions requesting for this training. So most of them are taking positive.
Under what circumstance?
There are a few of them who have completely gone under the radar as if we don't exist, and they obviously should be listening now.
You said that selling data is a no-no.
Yes.
Are you saying there's no circumstance under which that can happen?
If you are a marketing company, so that selling data is your core business, that is what you tell your customers. That is the basis on which you collect their consent. Okay. And so
I must know. You have to tell me
exactly
firsthand that you're going to sell my data.
This is what I do for a living. Are you happy for me to do it? Are you happy for me to market your data on collection? If the person's happy, they allow you to do it. If not, you must declare your sources. So secondary, the whole point about marketing is secondary sources of data collection are illegal unless you have legitimate grounds. You can't go buy the data that somebody has legitimately collected for one purpose and then begin to sell.
Oh, I get what you're saying.
Exactly.
Such as happened in this case that the Auditor General has captured with the EC.
Exactly.
So the EC is the original data collector, and then a third party goes. You're saying that can happen?
No, unless at the point of collection, the EC had informed the electorate that
on
point. Collection, after we have your database, we will market to you. If they had declared that at the beginning, then that would be consented. Then that would be fine. But they haven't. They have assured the people that is the for the purpose of voting. So, so that is what it should be for.
So, Kojo, we are where we are now with this, and it's a test case.
Yes.
How we navigate it will show whether we're going to come back here or not. The system obviously isn't, and we're talking about this now because we thought we should, right? But the focus was overwhelmingly on the corruption angle. The Auditor General has found that there was no agreement to this, 20% was not paid. And I remember isolating the data protection angle. This is a boring conversation to have. There's a sense that as a country, we're just not, this is not a priority for us. And people say it shouldn't be a priority.
In this particular
there are too many things to worry about than data protection.
In this particular, every jurisdiction and what is a big deal for them.
Data protection is not a big deal for us.
No, I mean under data protection. If you go into an Arab country, religion is a big deal in these countries. Whether you are Christian or Muslim is a big deal in certain jurisdictions. It is not for us in Ghana because there's harmony. There's harmony. If you go to a certain jurisdiction,
race by
race. For those of us who've lived abroad before, we know that race is a big deal.
So the point is, in this jurisdiction,
in Ghana, your political affiliation, it is a big deal. In this jurisdiction. And so the database that ensures the integrity of such a database is a sensitive database for most people.
Now I get the point you're making. So Kojo, you deal with elections a lot because of your work, etc. So the point she's making is, we're looking at this as a breach of people's personal data.
The integrity of the
it could
database.
also be integrity. This is electoral data that a private company holds and decide to sell it. That same private company can can use it for all other
Data
means that could have
aggregation.
impact
Yeah,
Yes.
sure. I mean,
on outcomes of
for
elections.
example,
analysis,
take
yes.
redistricting
Yeah.
or gerrymandering, for instance. So with that kind of data, knowing the location of people, because when you do, you collect data for register.
You know, location data is personal
location
data
and
as
so
well.
on.
Yeah.
You can decide that, okay, I feel that these are the areas where my voters are, and so when I want to draw the new constituency, you know, it needs to cover this side. You have that kind of data to allow you to do that. This happens in the US all the time in terms of the way people gerrymander. So it can be actually, you know, subvert the whole democratic process.
That's true.
Because you don't know. You see, nobody is saying that the data cannot be passed on. What are the conditions? Is that within law? If we all know and we give consent to it, then there's no problem.
Like we consent that the party should get it at a certain time.
Exactly.
The law has to specify the time frame.
Yes.
I think within 60 days before the election.
Yes,
So.
and before it's certified, and nobody else. Once it's certified, that is it. You can't go and add to the to the list because otherwise, then it makes it again not a final register. So all of these safeguards are there to ensure that there's transparency and there's credibility in the electoral system. And that's why the data protection is important. So for me, I see three things. There is the procurement issues and the public financial management issues. That is still follow-up. You know, we haven't resolved
that, yeah.
you know, commissioners have been removed because of these things. We need to resolve that. Then there's the data protection issue and the infrastructure, the technology that the EC is using to protect sensitive data.
The risk of unsolicited messaging during the campaign period, the risk of profiling, all of these exist if there's no integrity in the database.
So we have to, because when you are talking about register now, when you get to results and transmission and all, these are all data that you have to have a robust system, and there has to be clarity as to how that data is passed on to anybody else. So that has to be handled. Then, of course, you know, we have to ensure that, you know, the governance process around and the education around privacy issues is also addressed. So for me, maybe the Data Commission will be able to solve some part of it, but it also is something we have to pay attention to make sure that after the fact, the systems that have to be put in place is there.
You know, I listen to you talking, I'm wondering why the parties who usually are very alert to these things haven't said anything about this.
Well, maybe they didn't even know that. And if the audit has not been done.
That this same data that they fight the EC about.
Yes.
It's always one of the most divisive issues.
Of course, it is.
And yet, here we are. EC is giving it to a private company for money.
And it's not even collecting the money.
And the parties haven't said a word about it.
So,
I mean, that
so I would be interested to know the format in which they gave it because a big part of the struggle, I mean, as I say, even for us, is the format in which you get it.
Yeah.
Because you can't do anything with it.
other than just
to run, you know, tests and all of those. You can't do it for privacy reasons, and that's the kind of conditions they set. So if they gave it to some private company and it was all
it hasn't come up on
accessible and all of that.
Thank you very much for joining us. We wish you well in your fight with the EC. Let's see how that goes, and how you're able to, I guess, sanitize the system to get us on the path where most countries are already taking the lead on this already. So that's it for PM Express tonight. Hopefully you've learned something. I have. My guests have been Mrs. Patricia Dusepoku, who she's the head of the Data Protection Commission. Dr. Kojo Asante is the Director for Advocacy and Policy in Ghana, the CD. Enjoy your evening. Hopefully you know who is managing your data and what legal obligations they have as far as you're concerned in managing that data. My name is Evan Spencer. Enjoy the rest of the evening.